Ms. Johnson, I see you are in our virtual courtroom. There is no one appearing on behalf of the appellant. As you, I'm sure, already know, we are very familiar with the briefs and the record. So you may address those things that you want to address. And if the panel has any questions, then obviously we will ask them. But you.
Thank you, Your Honor. May it please the court. My name is Andrea Johnson, and I have the pleasure of representing the appellee, Roy Griever. This case was about damages for breach of trust. The trial court did not commit any error when it entered the judgment for $450,000 as an award of damages that Roy suffered based upon the trustee's breach of trust. The trial court's findings of fact are supported by competent substantial evidence that the trustee committed not only one or two, but a total of 14 breaches of trust during her administration of the Griever-Berg Trust. Because the record has competent substantial evidence, the trial court's findings are presumed correct. They are to be given all reasonable inferences that can be drawn from the evidence. This court cannot reweigh the evidence, and the trial court's determination—
Ms. Johnson,
Yes.
we've read the briefs. I have a few questions for you, and one of them requires a little bit of a lead-in, having to do with our relinquishment of jurisdiction in this case, and which directed the court to either get a stipulation or conduct an evidentiary hearing as to the amount remaining in the trust. The court declined to do that. And I'm curious as to how you would like to have us understand what the court did do constituted compliance with our order.
Yes, Your Honor. The court entered on November 1, 2019 on its own. You're right that there was not a hearing. The amended final judgment, and the court specifically went through each count and reiterated the rulings and incorporated the oral rulings. As far as the specific amount of the award of damages, of course, that amount remains the same, $450,000. But in the amended judgment, the trial judge said $450,000 being held in the trust account will immediately be released to the plaintiff. And then parenthetically, if it has not already been transferred pursuant to this court's oral ruling, and then the remaining funds in the trust account will be preserved/held until further order of the court. And so the amended final judgment does not have the specific balance of the trust account. But I think what this court's order required was a specific amount for it to be a final appealable judgment, which the amended final judgment does clarify. For purposes of entering a judgment, an award of damages and judgment, the balance of the trust really is not relevant for that purpose. The judgment simply needs to be clear that the amount that was awarded to Roy, because the balance only becomes relevant if it were purposes of—
Well, let's talk about the balance that was awarded to Roy. It seems to me that the previous finding was that the account had about $360,000 in it. And then when we get to the November hearing, the judge says $450,000 is in there. And the fee judgment states that there's about $78,000 in the account as of December 2019, which adds up to about $520,000. But the breakdown of the award that you've given us and that this seems to rest on includes the $37,000 from the Southern Oaks insurance check, which your client disavowed any claim to. Can you reconcile that issue for us?
The Southern Oaks check is not in the balance that is in the amended final judgment or the judgment for the attorney's fees. The relevance of the Southern Oaks check was when Roy was presenting evidence as to the measure of damages as to what his trust distribution would have been if the trustee had accepted the $1 million in August 2013. So for purposes of calculating the $450,000 judgment that was awarded, that was included. But what Roy was not seeking was damages in that amount to be tacked on to the damages for him not receiving his distribution when the offer should have been accepted. And so the Southern Oaks check is not in the actual trust balance that's in these judgments.
Ms. Johnson, help me out with that last point. And admittedly, math has never been my strong suit, and I don't claim to be an accountant. But if you are crediting or debiting, however you would call it, the Oaks insurance check vis-a-vis how you value what the property would have sold for purposes of ultimately determining what his distribution is, isn't that just a backdoor way of counting the check towards his distribution, which is what this issue and this argument really pertains to?
It's not a backdoor way because Roy had to present evidence as to what his distribution would have been. And the testimony at trial from the trustee was that this check was available to pay expenses. And so when you are measuring damages in a breach of trust, you are in a unique situation because you really have to go back in time. If there hadn't been a breach,
Right.
the Southern Oaks check would have been available within this pot of money to
Right.
include into the sales proceeds. And so you add all of that together, subtract the closing, subtract the alleged expenses up to that point in time, which is the basis for the request that Roy be awarded the $450,000.
Right. And my concern is that if you were to put that in a ledger, he basically ends up with credit for that check by virtue of the fact that it's now going to be offsetting expenses such that he gets a bigger payout than he otherwise would without consideration of that check. It just seemed, I mean, again, it just seems to me like that's just another way of counting the check. You're not seeking in damages and getting a direct dollar for dollar damage award for it, but it is being considered in terms of what his ultimate payout is.
It is being considered in the ultimate payout because if we go back in time, that money would have been there to pay expenses up to that point.
With respect to the accounting claim, your opponent contends that the judge never did an accounting. And my understanding of the trial court's ruling was that, starting with the fact that your client pled for an accounting, but the court didn't, I think we can all agree that an accounting was not conducted here. Is that right?
Not necessarily. As to the accounting argument, count 4 of Roy's second amended and supplemental complaint was a count to compel the trustee to perform an accounting. That's different than requesting an account.
It was not an accounting by the court. It was a trustee's accounting, providing information as to what was brought in, what has gone out, not the typical accounting by a trial court for a corporate entity where there seems to be some question as to wrongdoing. And obviously here there is a question of potential wrongdoing, but it was not the typical accounting that was sought. It was a fiduciary's accounting.
It was a statutory fiduciary accounting of the trustee because she had not accounted. Now, Roy's main claim at trial was for damages. He prevailed on the count 4 for accounting, which means the removed trustee arguably should provide an accounting. Of course, that hasn't happened, but the count 4 of Roy's is different than the argument that the trustee is trying to make here on appeal. She's trying to say that the trial court should have performed an accounting. And I will point out that the trustee neither sued Reenie's estate nor Roy for an accounting that she's now asking for on appeal. And in fact, in her initial counterclaim, she had asked in count 4 for a judicial declaration as to the reasonable expenses that she could reimburse her and her husband. After the property sold and she had the sales proceeds, she dropped that count. So at trial, there was never an action for an accounting pled. So she waived it and it cannot be raised for the first time on appeal.
One question I have as to the $450,000, your client testified as to that amount, but it also seemed to be that it was around 450. So what I'm struggling with is if we try to do the math as to an exact figure, how do we come up with exactly $450,000?
The mathematical calculation is set forth in pages 20 and 21 of Roy's answer brief. The most
but that is based on certain assumptions, correct?
No, it's based on record evidence. All of the documents and numbers are in the record to come up with that amount. It is $694. Roy rounded it down to $450,000. It was technically $450,000, $694.25.
And so we know that the other side challenged the numbers and presented contrary evidence. And it appears that the court, I mean, I guess what concerns me is I'm struggling with whether the court did an independent calculation to make sure it added up and or simply accepted the testimony of your client, which, as I think Judge Lucas pointed out, none of us are math majors. That's not why we are here. But trying to put that all together is a bit of a struggle.
There is not a mathematical calculation in the judgment that is accurate, but the scope of this court's review is there competent substantial evidence in the record to support the amount in the judgment? The $1 million value of the offer was in evidence. Roy's testimony that he was seeking, you've already acknowledged that was in evidence. The closing statement for the 2016 sale was in evidence to calculate the 2013. The trustee's chart of expenses to show what should be deducted was in evidence. And,
sure. One of the things that she claimed was I think it was 2015 taxes that were not properly accounted for. So how were those accounted for?
The offer did not address the taxes, so that is not in the mathematical calculation. However, I believe the trustee has submitted that number would be about $6,000. The trustee submitted evidence that he had actually overpaid $10,000. So if there is an issue with the real estate taxes, it would not be any error against Roy because the evidence was that he overpaid it. So if there is supposed to be an offset against the $450,000, it already is in there with his overpayment.
Assuming the trial court simply accepted the 450 as accurate.
Yes, but as long as there is competent substantial evidence in the record to support the number, the judgment should be affirmed. And in addition to continuing on citing the record evidence, the Southern Oaks check was in evidence, as well as as I said, the charts, which were used to support the calculation that is on page 20 and 21 of the answer brief.
Let's talk about the contempt issues that your opponent is arguing. As a general proposition, medical related absences aren't truly voluntary. She wasn't there for the last section of the bench trial that was held. Does a history of her prior continuances in any way warrant disregarding her right to be present for the last hearing?
I believe taking all of her actions into account, yes, that can be considered. But I first want to say that whatever this court does with the indirect criminal contempt, it would not affect Roy's judgment for $450,000 in damages. So if this court decides the finding her in indirect criminal contempt was erroneous, that still does not warrant reversal of the judgment for damages. But specifically addressing—
Well, it would warrant reversal of the fee award, wouldn't it?
It would not, because there is an alternative basis that fees were awarded under 736.1004.
How do we separate? Is there a way, looking at those fees, to isolate the fees that were awardable pursuant to the statute versus the fees that the trial judge imposed as a sanction?
They are one and the same. The evidentiary hearing, the timesheets that were entered, it was only one amount of total attorney's fees that were being sought, both under the breach of trust statute as well as consistent with the sanction that the trial court awarded. No separate fees were being sought for either.
It seems like, it seems like the only sanction that is arguably different is removing her as trustee of the trust. But even that was addressed in the amended final judgment as a result of what the court found to be her gross misconduct.
Yes, if Roy had not filed the motion for indirect criminal contempt, the trial would have occurred. He still would have had count 1 for damages for breach of trust, count 2 to remove her as trustee, count 3 was the declaratory judgment, and count 4 was to require her to perform an accounting. So all of the relief in the judgment granted in favor of Roy, there's nothing different in the indirect criminal contempt.
Related to that, Ms. Johnson, help me out. How did we get, what in the record can I look at that tells me how we got from the pleaded request to remove her as trustee and appoint an independent trustee to having Roy appointed trustee? How do we get there?
You are accurate that Roy in his pleadings requested if she was removed that an independent trustee be appointed. The trial court at its verbal ruling after closing arguments was the one who on his own appointed Roy. But I assert to this court that that was not air, because under the 736 statute that allows the court to remedy a breach of trust, I believe it's subsection 2J, the court has broad authority to enter such other and further relief that it deems appropriate. And I think a reasonable inference from the trial judge appointing Roy was that so that the damage payment could be effectuated quickly.
I don't know that I can agree that what is, I think we all would recognize as kind of standard boilerplate, general other relief as the court deems appropriate can be read and stretched so far as to provide a remedy that is actually contrary, arguably contrary to what he sought. What he sought was an independent trustee. What he got was himself. I don't know how you square that within the such other relief as the court deems appropriate.
To clarify, that was pled for Roy, but I am referring to 736.1001 subsection 2J that gives the court wide latitude to remedy a breach of trust. And I would submit to this court that one of those remedies is, rather than appointing an independent, the court had authority to appoint Roy to effectuate the transfer.
And that's where I'm struggling with. I'm not sure that the statute gives authority to venture beyond what is actually pled, which arguably is what happened here. It just depends. I mean, it depends on how you frame it. I mean, if you look at it from a certain vantage, it's just a clarification of, yes, she was removed. That's what he sought. But if you just pull up a couple of more feet, it looks very different from what he sought. So I'm struggling with that aspect.
I think the key is that he pled to remove her because she breached her duty to get her out as trustee, and the court did that. And there is no further administration of this trust to happen. There's no trustee needed because after payment of the award damage and the partial payment of attorney's fees, that is the balance of the trust.
The problem, of course, though, is if this panel were to determine that, maybe some of the math was a little bit too behind the, other side of a napkin in terms of how it was, and we were to reverse, then the identity of the trustee, becomes very important.
If this court were to reverse, which if there's a calculation issue, it doesn't warrant reversing the findings of fact that she breached or that Roy was entitled to damages, it would simply be for the trial court to conduct another hearing to do the specific mathematical calculation. And that would be evidence presented at the court below based upon the trial evidence already submitted in evidence.
And Ms. Johnson, you have less than a minute remaining if you want to go ahead and wrap up, absent any questions from the panel.
Yeah, absent any questions from the panel, great deference is given to the trial court's findings. And because there is sufficient, competent, substantial evidence that supports the $450,000 award of damages, Roy would request that this court affirm all of the orders that are under appeal.
Very good. Thank you very much. And